You got arrested, and you're pretty sure this officer never read you your rights. That means the entire case gets thrown out, right? Almost certainly not. And that misunderstanding has sent more people to prison than almost any other mistake in criminal law. Miranda rights don't work the way people think. They don't apply every time you talk to police. They don't automatically get your charges dropped. And they started right here in Phoenix, 1963, with a case that changed American law forever. I'm Richard Suzuki, former federal and state prosecutor, now criminal defense attorney here in Phoenix. Today, I'm going to show you exactly what Miranda protects, what it doesn't protect, and where the line is that most people don't see until it's too late. In 1963, a man named Ernesto Miranda was arrested in Phoenix, taken to the police station, questioned for 2 hours, and signed a confession. Nobody told him he had the right to an attorney. Nobody told him he could stay silent. His confession was used to convict him. His attorneys appealed all the way to the United States Supreme Court, and in 1968, the Supreme Court ruled that the confession was inadmissible because Miranda hadn't been warned of his rights. That decision, Miranda v. Arizona, fundamentally changed American law enforcement. Every police officer in the country now has to recite those warnings before a custodial interrogation. The case originated in Phoenix, and it remains one of the most important criminal law decisions in American history. If you live in Arizona, you have a direct connection to that history. But what exactly did the Supreme Court require? That's where things get complicated. Miranda warnings are required when two conditions are both present simultaneously. Not one, both. First, you must be in custody. That means you are not free to leave. You've been arrested, or the circumstances are such that a reasonable person would not feel free to walk away. Simply being questioned by the police does not put you in custody. Being asked to come involuntarily does not put you in custody. Being stopped on the street does not put you into custody. Second, you must be subject to interrogation. That means police are asking questions designed to elicit incriminating responses. Routine booking questions, your name, your address, your date of birth, are generally not considered interrogation. Spontaneous statements you make without being asked are generally not considered the product of interrogation. Both conditions have to be met, custody and interrogation. If either one is absent, Miranda doesn't apply, and anything you say can potentially be used against you, even without the warnings. Misconception number one: if police don't read me my Miranda, my case gets thrown out. This is the most common misunderstanding, and it's almost completely wrong. If Miranda is violated, the remedy is typically that your statements get suppressed, meaning they can't be used against you at trial, but your case doesn't disappear. If the prosecution has other evidence, physical evidence, witness testimony, surveillance footage, none of that goes away because of a Miranda violation. Your statements might be excluded. Your case almost certainly will not be. Misconception number two: I can invoke Miranda by just staying silent. Wrong. The Supreme Court has ruled that to invoke your right to remain silent, you actually have to say something. You have to assert that right. The cleanest, clearest way to do it: I am invoking my right to remain silent. I want an attorney. Saying nothing is not enough. Nodding is not enough. You have to speak up to invoke the right to stay quiet. I know how ironic that sounds, but that's the law. Number three, Miranda applies anytime police are involved. It doesn't. Traffic stops are a perfect example. When an officer pulls you over and asks whether you've been drinking, you're generally not in custody in the legal sense, even though you certainly don't feel that way. The officer can use your answers against you. Roadside sobriety questioning happens constantly without Miranda warnings, and those statements are regularly used in DUI prosecutions. A real Miranda violation, where statements are properly challenged and suppressed, can be significant to a case. If prosecutors built their entire case around your confession, and that confession gets thrown out, they may not be able to proceed. This happens. It's not common, but it happens. And when it does, it can change everything. This is why having an experienced attorney review every statement you made and the circumstances under which you made it is so important. Not every Miranda issue is a slam dunk, but some of them are case changers. I've seen it from both sides. As a prosecutor, I lost statements I counted on. As a defense attorney, I've had statements suppressed that prosecutors thought were bulletproof. The key is knowing what to look for. Was the client actually in custody? Was questioning happening before the warnings were given? Were the warnings given incompletely? Did the client clearly invoke their right, and did questioning continue anyway? These are all questions a skilled defense attorney asks. Waiving your Miranda rights. Here's a danger that people walk into without realizing. If police read your Miranda warnings, you say, "Yes, I understand," and then you start talking. You just waived your Miranda rights voluntarily. The prosecution will use everything you said after that waiver. People waive their rights constantly, thinking they'll explain their way out. I'll just tell them what happened. My side makes sense. They'll understand. I've watched this play out hundreds of times. It almost never helps. It almost always hurts. The police are trained to keep you talking. They're trained to seem sympathetic. They're trained to make you think cooperation means confession. Understand this. You can invoke your Miranda rights even after waiving them if you've been talking and you decide mid-interrogation that you want a lawyer. You can say the words and the interrogation must stop. It's not too late until the conversation ends. But once you've said it, once you've invoked your right to counsel, police cannot reinitiate questioning without your attorney present under Edwards v. Arizona. If you invoke your right to silence, the rules are different. Police must respect that invocation, but they may be able to reapproach you after a period of time if they scrupulously honor your request. The protocol is simple, even if it's hard to follow in the moment. When you're arrested, 1, stay calm, don't resist, don't argue. 2, say these exact words. I am invoking my right to remain silent. I want an attorney. 3, then stop talking. Not mostly. Completely stop. Nothing about what happened. Nothing about who else was involved. Nothing about where you were. Nothing. The urge to explain yourself will almost be overwhelming. Resist it. 4, don't talk to other inmates about your case. Jail informants are real. Conversation in holding cells get reported. Assume everything you say inside the jail is being listened to. 5, call an attorney as soon as you have access to the phone. That's it. Those 5 steps protect you more than anything else you can do in those first few hours. One thing I want to flag, and we'll get into this much more deeply in later videos, federal cases work a bit differently. Federal agents are often more sophisticated in how they approach questioning. They've been investigating you sometimes for months or years before they ever knock on your door. When federal agents show up, they already know things. They're not fishing. The questions they ask are designed to get you to contradict yourself or make admissions that confirm what they already have. That's a different game, and it requires a different level of awareness. Here's where it gets really interesting. In the next video, I'm going to tell you something that most defense attorneys won't say on camera because I was the guy on the other side. I spent years as a federal and state prosecutor building drug cases. I know exactly how federal investigations start, how confidential informants get flipped, how wiretaps get authorized, and how in federal cases they stack mandatory minimums to force plea deals. If you or someone you know is facing federal drug charges, or you just want to understand how that machine works, you do not want to miss that video. I'll see you there.